Yes.
Welcome, learned friends, for this Nani Palkhivala Law Club. Today, our speaker is Mr. Jayprakash Somani, Advocate, Supreme Court of India. He has published more than 50 plus books on different case laws of Supreme Court. Today's session is related to CPC and part 1, where we will cover the section and order wise contents about the CPC. Over to sir.
Thank you. Thank you, Manoj. So, friends, welcome to this Nani Palkhivala Law Club series. And in last session, we have seen the different classification of all Indian laws, and that video is available on YouTube now. And in that video, already in last program, I announced from next episode, we will start one by one different laws. So first, we will complete procedural laws. So most popular procedural laws are Code of Civil Procedure, 1908, then Code of Criminal Procedure, then IPC, then Evidence Act, Limitation Act, Constitution of India. These are the major. So we will cover all these acts first, and then gradually we will enter in corporate law, we will enter in other criminal laws, and not only law we will complete with its procedure also. For example, Company Law, Company Act 2013. Act is one, but rules to implement that act is near about 41. So it is very exhaustive. But those who are practicing corporate law, those who are practicing in regular course, they should know in what section what content is there. The content of each section, you should know that. And I want to create such type of videos. So while doing your morning exercise or your leisure work, you can just run that and you hear it again. And if you have time, you can watch that also. So let me start CPC. So first, I will share you the screen. Now, I hope you all are watching screen now. I will reduce this screen also. Yes. So, Code of Civil Procedure, 1908. Today, date is 7th August 2023. And I have updated version of CPC in front of you now. So it is on 5th August 2023. So it is updated now. So remember that whatever in this video is there up to 5th August 2023. Total sections in a CPC are 158. And all these 158 sections are in 11 parts. And after this, schedule first will start. And schedule first contains order first to 51st. That means 51 orders are there. So law and procedure both are combined in CPC. So law is 158 sections, which are scattered in 11 part, and its procedure is given in schedule 1 from order 1 to order 51. That is very exhaustive. So as a lawyer or as a law student, we should know what is in each section and what is in each order. So let me start. So preamble is given in CPC. The name of this code is the Code of Civil Procedure 1908. Section 1, regular as it is. Yeah, you know, this is a commencement and applicability of this act all over India, including Jammu and Kashmir now. Section 2s are related to definition. Section 3 related to subordination of courts. Section 4, savings. Section 5, application of the code to revenue courts. Section 6, pecuniary jurisdictions. Section 7, provisional small causes courts. Section 8, precedenti small causes courts. Now part 1. Suits in general. In part 1, sections are related to suits in general. How suit will file like that. Section 9 to 14 is jurisdiction of the court and res judicata. Some important section will go inside also. We will see that section also and we will come again here. But I don't want to make this video boring by doing unnecessary discussions. So section 9 is related to courts to try all civil suits unless barred. Section 10 is related to stay of suit. Section 11 is related to res judicata. Res judicata means a case which is already decided cannot be decided again. In criminal law, double jeopardy like that. This is a civil. So if we click on that, then we comes to know what is res judicata. No court shall try any suit or issue in which the matter directed or substantially in issue has been directly or substantially in issue in a former suit between the same parties or between parties under whom they or any of them claim litigating under the same title in a court competent to try such subsequent suit or the suit in which such issue has been substantially raised. So once that case, that issues already discussed and decided, so it cannot be decided again. So it is given in this res judicata. So friends, section 12 is related to bar to further suits. Section 30 is related to when foreign judgment not conclusive. If you want to related any term related to foreign judgment, applicability of foreign judgment, implement of foreign judgment in our country, then you can read section 13. Section 14, presumption as to foreign judgments. Section 15 to 25, place of suing, where we can file the suit. So section 15, court in which suit to be instituted. So if we click this, we comes to know every suit shall be instituted in the court of the lowest grade competent to try it. Okay, that means civil court junior division, civil court senior division. So this division, but up to which monetary part it will be admitted in the junior division, after which monetary part it will admit into senior division, that is given in orders, that is in procedures. This is law, this procedure is in orders. And some important case laws are Oxbridge Association Limited versus Atul Khurana. This is our latest 2023 case. Dasi Sudhakar Reddy and others versus Kotala Venkateshwara Reddy. This is the latest case in 2023, which is related to this particular section. Section 15. Section 16, suits to be instituted where subject matter is situated. When subject matter is situated, suppose when property, in which area property is that, in that particular jurisdiction court, it can be filed. Section 17, suits for immovable property situate within the jurisdiction of different courts. When in different court jurisdictions, suppose some property are situated, at that time, how it will work, it is given in section 17. Section 18, place of institution of suit where local limit of jurisdiction of courts are uncertain. Section 19, suits for compensation for wrongs to person or movables. Section 20, other suits to be instituted where dependent reside or cause of action arises. Section 21, objection to the jurisdictions. Section 21A, bar on a suit to set aside decree on objection as to place of suing. When objection is on place of suing, that time bar to suit to be set aside decree. So it is given in section 21A. Section 22, power to transfer suit which may be instituted in more than one court. Section 23, to what court application lies. Section 24, general power of transfer and withdrawal. Section 25, power of Supreme Court to transfer suits. You will find separate video of mine. As a practicing lawyer in Supreme Court, from one state to another state, transfer can be done only through Supreme Court. And there are two types of cases. One are civil and another are criminal. In civil, as per section 25 of the CPC, Supreme Court have power to transfer case of civil nature from one state to another state. And for criminal transfer, section 406 of CRPC is there. Section 26, institution of suits. Section 27 to 32, summons and discoveries. Section 27, summons to dependents. Section 20, now this is here again properly, 27 to 32 is related to summons and discovery. When you are searching some summons procedure, discovery procedure, so just go to section 27 to 32. Section 27, summons to defendant. Section 20, dependent means opposite party. Plaintiff and dependent. Plaintiff, it is petitioner who is filing the suit, is called plaintiff in civil cases. And opposite party is a defendant who is defending that case. So dependent. Who is putting plaint? Plaint means civil petition. Civil petition is called plaint. Who is filing plaint is called plaintiff. And who is defending that case is called dependent. So 27, summons to defendant. 28 section, service of summons where dependent resides in another state. So another state. So also through that court like that, summons can be served. Section 29, service of foreign summonses. Section 30, power to order discovery and the like. Section 31, summons to witnesses. Summons to defendant is a different. Who is defending the case? Against whom we file the case? Dependent. Now, when we file some evidences and after getting exhibit number of that particular evidences, that time to prove that document, we call some witnesses. That means summons to witnesses is under Section 31. Section 32, penalty for default. Section 33, judgment and decree. Section 34, interest. Section 34 is interest, costs. Section 35 to 35B, costs. 35 cost, 35A, compensatory cost in respect of the false and vexatious claims or defenses. If bogus claim, bogus like that, we file that. So that time we have to pay the cost. Section 35B, cost for causing delay. This is the part 1. Now part 2, execution. After getting in a decree in our favor, then how that, after getting decree, how we will execute it. So execution given is second part. So we will take in all this in a revision at the end also. What is in first part, what is in second part. So first part is related to suits, general rules regarding to suits. And second part is related to execution of that particular decree which are in the favor of plaintiff. So section 36 to 37, general. Section 36 is related to application to order. Section 37, definition of court which pass a decree. Section 38 to 46, courts by which decree may be executed. Section 38, courts by which decree may executed. Section 39, transfer of decree. Section 40, transfer of decree to court in another state. Section 41, result of execution proceedings to be certified. Section 42, powers of court in executing transferring decree. Section 43, execution of decrees passed by civil courts in place to which this code does not extend. Section 44, execution of decree passed by the revenue courts in places to which this code does not extend. Section 44A, execution of decree passed by the courts in reciprocating territory. Section 45, execution of decree outside India. Yes, Indian decree can be executed outside India also through that particular country's court. So provision is given in section 45. Section 46, precepts. Section 47, questions to be determined by the court executing decree. Section 48, execution barred in certain cases. This is now repealed. Section 49 to 50, transferee and legal representative. Section 49, transferee. Section 50, legal representative. Suppose we transfer this decree, execution decree to another person, then he can execute that. And if a plaintiff died, that time his legal representative can execute that decree. So these provisions are given in section 49 and section 50. Section 49 is related to transferee. Section 50 is related to friends legal representative. Section 51 to 54, procedure in execution. Now detailed procedure is there. Section 51, power of court to enforce execution. Section 52, enforcement of decree against legal representatives. Legal representative of defendant. Enforcement of decree against legal representative. Section 53, liability of ancestral property. Section 54, partition of estate or separation of share. Section 55 to 59, arrest and detention. Section 55 is related to arrest and detention. Section 56 is related to prohibition of arrest or detention of woman in execution of decree for money. So when execution decree is related to money, there is a provision not to arrest to woman. So that provision is given in section 56. So when you file any execution suit, that time you should read this part 2 sections. So gradually in the period of time or the period of time, you automatically remember these sections. But as a lawyer, whatever practice we have, some lawyer will have 5 years practice, 10 years practice, 15 years practice, 30-year practice. You are retired as a High Court judge. Now you are practicing as a lawyer in Supreme Court also. Even though my recommendation is this, every year you should read at least this procedure 5 to 6 laws from section 1 to last section. That is called read this granth. These are the granth of our practice. So yeah, and to make this work easy, so we are providing this video. So in lesser time also, you can play it on your TV or whatever gadget you have, and you can remember this section. So friends, section 57 is subsistence allowances. Section 58, detention and release. Section 59 is release on ground of illness. Section 60 to 64, attachment. For the execution of decree, we can attach that their property, defendant's property, like that. So section 60, property liable to attachment and sale in execution of decree. Now, I'm presenting in the eye through the eyes of plaintiff, but you may be, or I may be a lawyer of defendant also. So when we are reading these sections through the eyes of plaintiff, same way we should listen this section through the eyes of defendant also. So how we can cross this particular process through the eyes of defendant. We should have that logic also. So automatically that logic will gradually develop. Section 60, property liable to attachment and sale in execution of decree. 61, partial exemption of agriculture produce. So agriculture produce cannot be attached. That is called partial exemption is there. Section 62, seizure of property in dwelling house. Section 63, property attached in execution of decree of several courts. Section 64, private alienation of property after attachment to be void. 64 is related to private alienation of property after attachment to be void. Section 65 to 74, sales. Section 65, purchase titles, purchaser's titles. Section 66 is related to suit against purchaser not maintainable on the ground of purchase being on behalf of the plaintiff. It is now repelled. Repelled means it is cancelled. Section 67, power of state government to make rule as to sales of land in execution of decree for payment of money. So state government have power, that is under 67, to make the rules for money suits. Section 68 to 72, delegation to collector of power to execute decree against immobile property. It is, this section is also now repealed. Section 73, distribution of assets. Section 73, proceeds of execution shall to be ratably distributed among decree holders. Section 74, resistance to execution. Now we are in part 3, incidental proceedings. Section 75 to 78, commission. Section 75, power to court to issue commission. Commission means when court is not liable to go and inspect that particular spot. In that circumstances, court can appoint any lawyer on behalf of that court as a commission, as a commissioner, and that commission can take the evidences there, take the statement of witnesses there, go and inspect that property, and all report that particular commission will submit to the court. So this is called commission. So while commission lawyer, a lawyer who is appointed as a commissioner, that while he is acting as a commissioner, so he have the power of the judges. So at that particular period, he is the officer of the court. So no person can obstacle him, no person can create hazard in his investigation. Like these rules are here, and some rules are related to appointment also. Section 76, commission to another court. Section 77, letter of request. Section 78, commissions issued by foreign courts also. Now part 4. We have to complete 11 parts and total sections 158. I don't think it will cover today, but we will cover later also, but we'll try to cover what as much as possible today in this part 1. So part 4 now, suit in particular cases. Section 79 to 82, suits by or against the government or public officer in their official capacity. When you are filing civil suit against government or public officers in their official capacity, now these rules is here. These sections are here. Section 79, suits by or against government. Section 80, notice should be there. Section 81, exemption from arrest and personal appearances. Section 82, execution of decree. Section 83 to 87A, suits by alien. Alien means foreign person or from different planet also. We can place alien or foreign person by or against foreign rulers, ambassadors, or NOIs. So section 83, when alliance may sue. Section 84, when foreign states may sue. Sections 85, persons specially appointed by the government to prosecute or defend on behalf of the foreign rulers. Section 86, suits against foreign rulers, ambassadors, or NOIs. Section 87, style of foreign rulers as a parties to the suit. Section 87A, definitions of foreign state and rulers. Section 87B to 87B, suits against a ruler of foreign Indian state. Section 87B, application of Section 85 and 86 to ruler of former Indian state. Section 88, where interpleader suit may be instituted. Part 5, special proceedings. Section 89 to 89, arbitration. Section 89, settlement of dispute outside the court. That is called arbitration. Now, arbitration and Conciliation Act is there. You can find my small videos on that acts also. There are two type of my videos on YouTube. One is for general public, that may be sometime Hindi, English, maybe that is depend upon mood. But major big videos are majorly you will find in English, because that are developed for the legal fraternity, law student or lawyers. So you can find my small videos also there, and some big webinars also on Arbitration and Conciliation Act implementation, like that. So gradually we will cover that also. But now this is Code of Civil Procedure Part 4, Part 5. Section 89, Settlement of Dispute outside the court. Section 90, Power to state case for opinion of court. Section 91 to 93, Public Nuisance and other wrongful act affecting the public. Section 91, Public Nuisances and other wrongful acts affecting the public. Section 91, Public Charities. Section 93, Exercise of power of Advocate General outside presidency towns. Part 6, Supplemental Proceedings. Section 94, Supplemental Proceedings. Section 95, Compensation of obtaining arrest, attachment, or injunction on the insufficient grounds. Part 7, Appeals. So where we can file the appeals when we are not satisfied by the decision of the trial court, civil court, trial court. Section 96 to 97A, Appeal from original decree. Section 96, Appeal from original decree. Section 97, Appeal from final decree, where no appeal from preliminary decree. Section 98 is related to decision where appeal heard by 2 or more judges. Section 99, no decree to be reserved or modified for error, irregularity, not affecting merit or jurisdictions. Section 99A, no order under Section 47 to be reversed or modified unless a decision of the case is prejudicially affected. So this is very important. No order under Section 47 to be reversed or modified unless decision of the case is prejudicially affected. This is provision given in Section 99A. Now, Section 100 to 103, Appeal from appellate decree. When you file appeal from civil court to district civil court, that is first appeal, and then second appeal you can file into where? As per section second appeal 100. So this is in High Court. This appeal is in High Court. So High Court have the power to hear that appeal under Section 100. Section 100A, no further appeal in certain cases. Very petty cases are there, so no appeal is there. But when substantial question of law is there, when law point is there, then you can approach the court, and that is the discretion power of that particular court to whether to admit this case or not, like that. Section 101, second appeal or no other grounds. Section 102, no second appeal in certain cases. Section 103, power of High Court to determine issue of facts. Generally, in appellate court, issues, facts not again decided. But Section 103 has given power to High Court to determine issue of facts also. They can hear again, they can reconsider again, like that. So these are the power. When procedure any lawyer knows the perfect procedure now. So he can take each and every advantage of that particular procedure. And when procedure is not properly followed, that time we can take the benefit in our favor. Opposite party is not following proper procedure like that. So in criminal cases, sometimes we get the acquittal of the heinous criminals also, because police has not followed the proper procedure. So similar way in service matters also, in Supreme Court, all type of matter we have to handle. So you can find my different videos on different matters on YouTube, small video, 5 minutes, 10 minutes also, like video that. So in service matter, when anybody is dismissed from that services without following the proper procedure which is given in that particular organization's rules, so that dismissal is illegal. So such type of procedural lacuna, when we present before the court with proper section and proper citations, that will be a better thing, friends. Now, section 104 to 106, appeal from the orders. So these are the appeal from degree. Now these are the appeal from orders. Section 104, orders from which appeal lies. Section 105, other orders. Section 106, what courts to hear appeal. Section 107 to 108, general provision related to appeals. Section 107, power of appellate court. Appellate court have a power, different power. What are that power? You can go. You will find this power here as well as in orders also. Order, rule, that is the procedure. So CPC can be completed reading after sections and after orders. Orders are very exhaustive order, very interesting mannerly, in very interesting manner. Government has provided this code to us. This is 1908 code before independence, but CPC initiated in our was initiated in our country in 18th century, in 19th century, 1857. First draft, I think 1857, near about that. First draft was drafted by some British expert juries. So that name is there, but I don't remember that name. You can find it in Google or on Law Ministry site in CPC. So section 106, what courts to hear appeal. Same section 107 to 108, general provision related to appeals. Section 107, power of appellate court. Section 108, procedure in appeal from appellate decree and orders. Section 109 to 112, appeal to Supreme Court. Section 109, when appeal lies to the Supreme Court. Section 110, value of subject matter. It is now repealed. Section 119, bar of certain appeals. It is now repealed. Repealed means cancelled. That section is cancelled. Section 111A, appeals to federal court. Repeal. Section 112, savings. Part 8, reference, review, and revision. Section 113, reference to High Court. Section 114, review. Section 115, revision. What is the difference between appeal and reference and review? So practically, when you handle this, you will comes to know that the difference very cleanly and very cleverly you can understand. But when we are not finding satisfactory judgment in our favor, that time we can do the appeal. But sometime we have to file some references, reviews, revisions. Sometimes judges also take the reviews before passing the decree of their court. They are taking the reviews. they are sending that matter to appellate court, upper courts and upper court, then finding that and then review that. Sometimes parties can file the matter for review. Sometimes judiciary can take the review of upper judiciary like that. So part 9, special provision related to the high courts not being the courts of judicial commissioner. Section 116, part to apply only to certain high courts. Section 117, application of court to high courts. Section 119, execution of decree before ascertainment of cost. Section 119, unauthorized person not to address court. Only lawyer can address the court as per Advocate Act. Party in person can appear before the court with the permission of the court, not without the permission of the court. Party in person can approach the court directly, but with the permission from the court. He have to file one application. As a party in person, I want to appear in my case. Either you personally, you can argue or you can plead your cases, or through any advocate who are the member of any state bar council. And throughout India, you have the practice rights. You can practice when you take the any bar council. For instance, I have taken my registration from Bar Council of Maharashtra and Goa. So I can argue in any court of India, in any tribunal, including Supreme Court also. AOR is there. AORE, advocate on record, is for filing purpose. It means not that when we have to practice in Supreme Court, you should become an AOR. No. I don't want clerical work, so I have not applied for AOR. My books are on AOR. My students are becoming AOR. In my law firm, near about 7 AORs, juniors are with me. Non-juniors are 5 to 6, non-AOR. But arguing counsel, you can become. But when you are young, it is better to take AOR. Take that examination, give that examination, clear that examination, so you can get the good amount of matter filing. But when you shifted from High Court to Supreme Court in middle age, upper middle age, that time no need to join as a AOR. You join directly as an arguing counsel like me. This is my advice, because we can focus on argument like that. So argument focus, research, because juniors are there to do the research, juniors are there to draft the matters. We have to guide them, take this question of laws, take these grounds, take these matters, search out another case laws, take the relevant para. No, this is not relevant para, that is relevant para. Such type of guidance you have to give this. But when you are young, that time it is better to give the examination of it. But it means not that in Supreme Court you cannot stand and practice unless and until you clear that AOR examination. No. Filing, for filing purpose, filing process, AOR system is there. Advocate on record. But any lawyer can appear before Supreme Court also as an arguing counsel. So unauthorized person do not address court as per section 119. Section 120, provisions not applicable to High Court in original civil jurisdictions. Part 10, rules. Section 121, 121, effect of rules in first schedule. So now this section are speaking about the orders related to orders, rules. Section 122, power of certain High Court to make rules. CPC, CRPC is for criminal procedure. CPC is for civil cases procedure. What is civil cases? What is criminal cases? The cases which are not criminal. All other cases are civil cases. This is layman's definition. But if you go in the code and you find the in section 2 definition, you will find the perfect definition of that. So when there is a private wrong, that is civil cases. When there is a public wrong, that is a criminal cases. So private wrong and public wrong, such type of little bit differences is there. So for that, all over India's court is following CPC, CRPC, including High Court and Supreme Court also. But High Court have power to frame their rules and Supreme Court have the power to frame their rules. So when you are practicing as a lawyer in High Court, that time it is your duty to find out that High Court's procedure also. And that is given now on the website of that particular High Court. Just take down that rules, read that also, and along with CPC, you refer that rules. When you are practicing Apex Court, Supreme Court Rule 2013 and Supreme Court Procedure and Practice 2017, 2 books are there. So we have to refer that mainly. CPC is less, but our rules books are more. You will find my separate webinar on Supreme Court Rules and Procedure, 2 hours webinar, which I have taken for lawyer long. I think I was taken that in the period of COVID. You will find out on YouTube channel. This is my hobby, friends. I'm not talented man. I'm not very clever man. I'm from rural area, from Marathi medium background, but from small town to Delhi and up to international arbitration matter, I travel. But no matter how your English is, your English should be a good to make proper communication. You should convey your feelings properly. You convey your point. Try to use proper words, proper legal words like that for that practice. So I have started one course also, Argue in English Fluently and Confidently. And that course is in a 16 part. So gradually that course is going ahead. 1-2 batches completed now. So if you want to find how exactly course that, just go on YouTube. You will find a AEFC part 2 there. That is open. That is open video. All other part video are hide video. So when we start new batch, that time you can, if you want, you can join. You will get the ideas how to argue, how to make the point, how to stand before the court like that. But as per concern the procedural part, so we should follow the procedure of CPC for civil cases, and along with that particular court's rules, while you are practicing in semi-apex court like High Court and apex court like Supreme Court. But district court and civil courts, CPC is sufficient for that. So section 122, power of certain High Court to make rules. Section 123, constitution of rule committee in certain states. Section 124, committee to report to High Court. Section 125, power of other High Court to make rules. Section 126, rule to be subject to approval. Section 127, publication of rules. That rules should be published in official gazette of that particular state when it is amended by the state. Because these procedural law are in concurrent list as per the Constitution of India. So concurrent list means a state can also do the amendment and central can also do the amendment. It is the central act, but state can make amendment as per their need because of it is concurrent list. Section 128, matter for which rules may provide. Section 129, power of High Courts to make rules as to their original civil procedure. Section 130, power of other High Courts to make rules as to matters other than procedure. Section 131, publication of rules. Part 9, miscellaneous. Sorry, not part 9, part 11. Last part was 10, now part 11. miscellaneous. Section 132, exemption of certain women from personal appearance. Section 133, exemption of other persons. Section 134, arrest other than in execution of decree. Section 135, exemption from the arrest under civil process. Section 135A, exemption of members of legislative bodies from arrest and detention under civil process. Section 136, procedure where person to be arrested or property to be attached in outside districts. Section 137, language of subordinate courts. So languages are always decided by their respective high courts. So Bombay High Court will decide which language Maharashtra Territory Court should operate. So they decided Marathi, so Marathi is in operation. Gujarat Court decided Gujarati, so language is Gujarati there. Okay, so like that. So that is provision given in here. Yeah. So section 138, power of High Court to require evidence to be recorded in English. Section 139, oath on affidavit by whom to be administered. Section 140, assessors in causes of salvage, etc. Section 141, miscellaneous proceedings. Section 142, orders and notices to be in writing. Section 143, postage. Section 144, application for restitution. Remember this, application for restitution. When ex parte, sometime ex parte decree passed, that time we don't know ex parte decree passed. Sometime dependent don't know, sometime dependent lawyer don't know, like that. So that time we can make one application to restitution of this case again in the court. So many times civil court give this liberty to restitute again, and this is in section 144 also, and this is in order also. So in order, detailed procedure is there. Section 145, enforcement of liability of surety. Surety means guarantor, who have given the guarantee to pay the debt. That is called surety, guarantor, jamindar, jamanatdar. The different words are there in different languages. Section 146, proceedings by or against representatives. Section 147, consent or agreement by person under disability. Section 148, enlargement of time. Section 148A, right to lodge a caveat. So caveat, right to lodge a caveat, which section, under which section we are filing caveat? This section 148A. 149, power to make up deficiency of court fees. What is caveat? You do already caveat. Lawyers, law students know the caveat, what is caveat. But if this video is watching by non-lawyer person, he should know what is caveat. Caveat means when you win the case in this court and when you feel opposite party will approach to appellate court. So before admitting that a case in appellate court should hear you also before admitting that. So you can find a caveat. Caveat means application to hear the suit before admitting that in appellate court. So such type of caveat procedure is also in Supreme Court also. We are filing the caveats and we are trying to dismiss that case at admission level also. That should be a powerful argument. We have to do that, friends. When we have the trust on gurus, when we have the trust on our laws, when we have the trust to give the relief to our client, our main motto should be to give the relief to the client. Money automatically we are running. This is my life's experience. Now I am running 59. In 1989, I have taken the registration. Now more than 35 years passed. Nobody is expert. When we are when we are initiating our law practice, that time we are initiating to become a law student. We are always a law student. Even though you will retire as a Chief Justice of India also, that time also you will be only a law student. So always be a law student. Don't become an expert. Don't claim you are expert. There are different laws, different classification, different rule, different procedure, but don't bother about that. Take any case. Don't get any stamp, criminal lawyer, civil lawyer, IT lawyer, don't get. Don't focus on any particular segment at initial stage. Automatically, public will give you in your favor. Automatically, some people are setting their practice in criminal side, some practice in IT, some are going in corporate, corporate law, some are going in cooperative laws, some are going in different categories. Patent law, like that. So, but at initial stage, don't make any classification. I have not done any classification till today now, but I have the privilege to handle all cases. While I was practicing in Bombay High Court and SESTAT, that time I was used to handle customs, excise cases, taxes cases. But while I've shifted into Supreme Court, I have privilege to handle the criminal, bail matter, regular appeals, also corporate matter, army matters, income tax appellate tribunals matters, CB appellate tribunal matter we are handling. All type of matter we are handling. Once your common sense is developed, yes, you can give relief. Just you have to read that law particular, this is procedure, read it, case laws, you have to do that. And when after sufficient time, when you have good juniors, good setup, that time you can easily handle any case in any court. Now, Section 150 is transfer of business. Section 151, savings of inherent power of the court. Section 152, amendment of judgment, decree, and order. Yes, there can be amendment in judgment, decree, and order. You have to file one application to amend that judgment in the same court, but that section, under which section you can file that application? 152. And under which order? When we will see that order, we will comes to know that orders. Section 153, general power to amend. Section 153A, power to amend decree or order where appeal is summarily dismissed. Section 153B, place of trial to be deemed to be open court. Section 154, savings of present right appeal. Now it is repealed. Section 155, amendment of certain acts, it is now repealed. Section 156, now it is repealed. Section 157, continuance of order under repeal enactment. Remember that. Even though enactment is repealed, cancelled, that law is cancelled, even though continuance of order of repealed enactments. Enactment means law. Why? Because before repealment of that particular enactment or law, before that, when suit is filed, so after enactment also that suit can be decided. So this is a section 157. Section 158, a reference to Code of Civil Procedure and other repealed enactment. And now Schedule 1, first schedule. So in next part, in CPC part 2, we will find orders. This is very exhaustive. Orders. 51 orders are there in CPC. I'm not threatening you. I'm not frightening you. These things are challenging. Take that challenge. CPC is, once you are in favor of civil cases, when you like the civil cases, when you like the CPC, that time you can impute in the country's wealth also, because you can handle taxation cases, you can handle corporate cases, you can handle property laws cases like that. So take the interest in CPC, orders, actions, related procedure like that, friends. So friends, for today, this is sufficient now. So Jai Hind, Vande Mataram. Thank you. Thank you very much. Good night. Thank you.